last class, we had started off with what is intellectual property, what does it mean to have the rights of intellectual property. We discussed on 4 different intellectual properties, starting with trademark, trade secrets. We also discussed the other forms over here. Trademark started with trademark, copyrights, trade secrets, and then we moved on to what is a patent. We learnt about the meaning of patent, right? It mostly, I told one word that you need to remember if it's a patent means invention. Remember, it's invention. We also learned that it's covered under the Patents Act of 1970. It extends to whole of India. That means it includes Jammu and Kashmir. It shall come into force as on the date the central government may publish in the official gazette. And the life of patent. So if you are an inventor and you've invented something, you can hold the complete rights over that invention for 20 years. After that, what happens? After 20 years, either you can renew your invention, patent rights, or you may let the public or let anybody else use your invention. Two options. Either you can renew your patent rights or you can let the public use it. What are the 3 basic elements we discussed? The patent must be absolutely new. Nobody else in the history should have invented it. Second, it must be put to industrial utilization. It must be useful, right? It can be a service, machine, or a good or a commodity. It must be useful and it must be non-obvious. We also looked at the types of patents, 2 different types, utility and design. Utility focuses on the working of a particular model or a machine or a product. As we look at the machine, focuses on working. On the other side, we focus on the outlook, that is the design of a product or device. So today we'll be looking at the procedure to get patent. What are the steps involved if you as an inventor want to get your patent rights? What is the procedure? The steps in filing for patent are 6 different steps. First, you apply for it. First step is application for grant of patent, and then provisional or complete specification. Number 3, statement and undertaking under the section 8. Number 4, declaration by inventor. Number 5, request for publication. Number 6, request for examination of application for patent. Let's look at each one. So your step 1 is, which is called as the form 1, application for grant of patent. So if you are an inventor, you first need to take this form and you need to fill in certain details, right? You will have to furnish information or details such as the name and address of the inventor. So your complete legal name, right? A complete name with the initials, everything, and the address of residence, and also information corresponding to prior patent applications relating to the current invention which any authorized identity has filed. So in case you are inventing a product A, okay, that's your current invention. Regarding the same invention, if somebody else in the history or in the past have filed a patent, okay, those applications information you will have to provide in this form. I repeat, if your invention is product A, that's your current invention, in this form you will also need to provide the details. If in case in the past or in the history anybody has filed a patent for the same product that today you have invented, such application details or inventor details you need to be providing in this form number 1. These are your basic details. If there is nobody who has invented or nobody has come across certain product that you have invented, then that's going to be a nil. If they have come across, then you need to provide the details. So this is the first step for a inventor to start in order to procedure to get a patent rights over his invention. Number 2, form number 2 is provisional or complete specification. It is used to furnish your patent specification. It can be provisional or complete depending on the type of patent application you are filing. Now here we are talking about provisional or complete. Why is it two options over here? Now there can be cases that sometimes when you're inventing something, it can be a machine or a procedure or a product, etc. It might take time for you to complete, okay, a couple of months. So you rather just put a is before somebody else puts a patent for the same invention, you try to put before completing your invention, call it as provisional patent rights. Okay, so that's when you put that provisional application. Or when you've completed your invention, it's complete, there's nothing else to do about it, it's complete, then it's called as complete patent. Understand? That's why there's two options: provisional, complete, specification. So why is this form used? It is used to furnish your patent specification. So step number 2 completely deals about your invention. Step 1 deals about your basic information. Step 2 deals about your current invention. What have you invented? Everything, specification. Does it belong to household, or does it belong to industry? Does it belong to factories, or does it belong to everyday usage? Right? Where can it be used? Right? How did you invent it? How did the idea come across your mind? Right? What are the materials have you used? Have you tested it? What is the outcome of the machine? Is it industrial usage? Right? Is it novelty, completely new? All these questions is what you need to answer in this form number 2. Completely you need to specify about your current invention. Is that clear? So that's completes your step number 2. Step 3 is form number 3 states that statement and undertaking as per under the section 8 of the Act furnish information relating to patent application filed in other countries for the current invention. Additionally, any information relating to the rights corresponding to the present patent application. So in case not just your home country, wherever the inventor resides, apart from that country details, any other country across the globe who has filed a patent for the same current invention that you have invented, in case they have filed, then you as an inventor must furnish such details of those applications filed in the other countries. Additionally, any information relating to the rights corresponding. So in case, what are the rights, right? In case I invent this, or this becomes I agree upon the patent rights, accept the patent rights, then what would be my rights? What would be the conditions of the invention? And as the owner of the invention, that is the inventor, what rights would it correspond to the invention? Everything must be presented or stated in this form number 3. Form number 4, step number 4, it's called as form 5, declaration by inventor. It is used to declare the inventors of the subject matter sought to be protected using the current patent application. So that means you need to declare that this invention, whatever I've invented, is completely by me. I have not copied from someone, or I have not duplicated someone's authorized work, but it is absolutely my own work or my own personal idea. Is that clear? So that is called as declaration by inventor. It is used to declare the inventors of the subject matter sought to be protected. Okay, so he has to make sure that he is the only one who was invented on so and so date on so and so particular time, and this belongs to him as an inventor. Nobody else can claim the rights of this invention. So that is called as subject matter sought to be protected. That means nobody else can use his invention rights. That's your step number 4, declaration by inventor. Step 5 is form number 9, request for publication. If this form is not filed, then the patent specification will be published by the patent office after 18 months from the priority date. So as an inventor, you must request the patent office to publish or publicize your invention or the details about your invention. If not, if you're not filing this step or this requesting for publication, then the patent office will, when will they publish? If not, after 18 months from the priority date. After 18 months from the priority date. What is the priority date? It is filing of the first patent application for the current subject matter. For your current invention called as product A, for example, if somebody else has uh, filed it, as we just mentioned in step number 1 and step 3 that we mentioned, right? If there is priorly, if anybody in the past have filed, let's say a year before somebody has filed the application for the same invention, then only after 18 months from the first date of the application will it be published. If you want it further or if you want it earlier to be published, then you need to request the patent office for publication. Because why? Your patent rights start from the date of publication. Understand? Why do I need to request for publication? The earlier it is published, the earlier you will have a legal right upon the invention. So you can start making money or you can start having profits over that invention. So until and unless that you can't do it, once it becomes public and the government gives you the patent rights, then you'll have rights over it and you can start making making profits based on that invention. That's the purpose behind requesting for publication. The last step, step number 6, is Form 18, request for examination of application for patent. This form can be filed within 48 months from the priority date. I just mentioned to you what do you mean by priority date here. So within 48 months, this form can be filed, that is request for examination. The patent office will not consider your patent application for examination unless this form is filed. So if you want your previous application, that is whoever is filed before you, to be examined, okay, whatever they filed, please examine it and examine mine and see what are the credentials with my invention. So in case you want to examine the other inventions, so you need to you need to submit a form 18 called as request for examination of application. So you need to go through thoroughly what kind of invention or what is the application that is formed, what are the specifications that we just studied in step 2, provisional or complete specification. So we need to check all those credentials before we grant the patent rights legally and publishing the information to the society. Is that clear? So this completes the procedure for filing your patent or getting patent rights. So next class will be looking at the pre-grant opposition and the post-grant opposition. Once you file, if there's anybody who wants to oppose your invention, how can they raise their voice? What is the criteria for raising the voice? That point we'll be looking in the next class. So today we have completed 6 different steps in order to file a patent. First is application for grant of patent. Second, provisional or complete specification. 3, statement and undertaking. 4, declaration by inventor. 5, request for publication. And number 6, request for examination of application for patent.